Good morning, everyone. My name is Greg Gott. I'm a member of the Triangle Lawyers chapter of the Federalist Society, as well as an attorney at Brooks Pierce here in Raleigh. I have the unenviable task of attempting to follow up on those wonderful tributes we just heard, but at least I had the pleasure of doing so while introducing our first panel at this year's chapters conference, the North Carolina Administrative State. Our panels provide an overview of the administrative state in North Carolina, focusing on the implications it has for both the separations of powers and for individual liberty. The moderator of our panel requires little introduction, and I'll leave it at that at his advice, Associate Justice Richard Dietz of the North Carolina Supreme Court. Our first panelist is Jeanette Doran, who currently serves as the chair of the North Carolina Rules Review Commission. She also is the president of the North Carolina Institute for Constitutional Law, where she oversees the Institute's mission of educating the public, the bar, and policymakers about constitutional principles and promoting liberty by encouraging a limited and transparent government. Our next panelist is William McKinney, a shareholder at Haynsworth, Sinkler, and Boyden, where he represents clients in governmental, economic development, and complex litigation matters. While in government service, Mr. McKinney served as general counsel to the governor of North Carolina, as well as special counsel to the Attorney General of North Carolina. And to round out our panel, we have Dr. and Judge Donald Vaart, the Chief Administrative Law Judge and Director of the North Carolina Office of Administrative Hearings. Dr. Vaart is a licensed attorney and holds a PhD in mechanical engineering from Cambridge University. Before being appointed to his current role, Dr. Vaart served as the Secretary of the North Carolina Department of Environmental Quality. Lastly, I'd be remiss not to mention that all the opinions expressed by our panelists are of those individual panelists and not of the Federalist Society, and that our panelists are appearing in their personal capacities, and their opinions may not reflect those of their employers, clients, or agencies with whom they are affiliated. And with that, please join me in welcoming the panelists for our first panel, the North Carolina Administrative State.
Well, good morning, everyone. I just want to start by thanking you all for being here for this panel. I'm very excited about it, but when the organizers called me and described the panel, it reminded me of years ago, I was on an ethics roundtable of appellate judges about brief writing. So it was Court of Appeals judges from intermediate appellate courts all around the country. And the topic was ethics in the sense of, if you're sort of cheating, like you're supposed to double space your brief and you kind of do like 1.9 spaces to make the word limit, or you delete the spaces out of a citation, make it all one word. And so when they put the notification about this program on social media, one of these, like the proverbial like rando on the internet, came in a comment with this big rant about how like this was everything wrong with lawyers, that how could you have an hour-long training session just about how to double space a brief or use spaces. And so all I can tell you is, that random guy is definitely not here today. We're going to talk for an hour about the state of the administrative state. And so I appreciate you all being here, but I think what you're going to find is this is actually a really interesting topic. You either know a lot about what's going on, in which case you're probably excited. The Supreme Court of the United States is about to take on some really interesting things in this area. There's a bunch going on in our state as well. And if you don't know about all these things that's going on, we're going to tell you about it, and I think you're going to realize how important this is. So I want to kick it off to the three panelists to let you all talk a little bit just broadly about the administrative state. To do that, whenever we talk about this, I always think about Senator Gene McCarthy. So, this is like the other Senator McCarthy, the progressive who had challenged Lyndon Johnson with sort of an anti-war platform. And, about 50 years ago, Time magazine quoted Senator McCarthy as saying, "The only thing that saves us from the bureaucracy is its inefficiency." And which I've always thought was funny. So my question to you all is, what is that bureaucracy that he's talking about? What, in your view, is the administrative state? So Jeanette, I'll start with you.
So actually, I apologize, folks. My mic isn't working, so my co-panelist is kind enough to share. I think the most important thing to remember about the administrative state is that it is the most intrusive aspect of law, and it is the least understood not only by the public at large, but frankly, very often by the bar. And I think some of that comes, at least specifically here in North Carolina, from the fact that we don't call our regulations, we call them rules. And you ask the average normal person on the street, you ask a non-lawyer, normal person, they don't think a rule is the law. And that's the first hurdle we need to overcome. And then we need to remember that these regulations, the ones that we hear about so often in the federal system at the U.S. Supreme Court level, involve huge sweeping regulatory schemes, and the people involved and the amici involved are massive corporations, and they're states against the federal government, they're agencies fighting with each other. But very often, regulations are manifesting themselves and interrupting our lives in very small ways. For example, in North Carolina, if your kid's in daycare and you want to pack lunch or breakfast for him, the daycare center can't just give your kid the meal that you packed for him. It has to be approved by nutritionists that the daycare center keeps on staff. Well, that's a day in, day out kind of interference in our rights as parents, but also in our fundamental liberty interests. And those are the areas where I think the average person doesn't understand just how pervasive the administrative state is on our daily lives. And that's, to me, what the administrative state is. It's this sort of big shadow looming over virtually every aspect of our lives. And it's a shadow we need to shine a light on. So that's my thought.
Sure. Well, first off, thank you, Justice Dietz, for the invitation to join with you. And I see a number of friends in the audience, people who I've learned a great deal from and admire. And so I'm happy to have a chance to visit with you today, albeit 2 feet up here on the dais. But I'm glad to talk a little bit about, from my perspective, the administrative state is what Jeanette said. It's an exercise of power. It's an exercise of sovereign authority. These are rules that are developed by an executive branch with authority given to them through the legislature. They extend and are admittedly wide-reaching, all-encompassing in many ways. And even on the state level, you've mentioned certain health standards, but there are also rules that govern the conduct of state agencies within their management of their own internal affairs, human relations, human resources, employment, your rights on the job, so to speak, as well as the rights of, the rules that govern the conduct of private actors that seek a permit or a license from the state to do various things. So I think the McCarthy quote from Gene McCarthy is well cited, Justice Dietz, that you've got within ALJ, it exists, in my mind, administrative law courts which review these rules. I mean, it's something of a riddle, right? It's an executive branch created through the judiciary. It has certain authorities that extend, but not to declaring a statute unconstitutional, because that's not authority that the General Assembly can delegate out from its own statutory authority. So, it exists in this really interesting space that balances 3 different exercises of sovereign authority: legislative, executive, and judicial. And I think that for that reason, it covers an incredible amount of ground, and how you, as a litigator or someone interested in the legal space, balance those interests, all fall to this one court. So in some ways, it's kind of a remarkable funnel that channels that activity both through the rulemaking and final agency decision process.
Thanks. As an engineer, taking a look at what is the administrative state, what I'm going to give you is certain phenomenon characterizing this entity. And then from that, sometimes you can derive more properties rather than knowing enough about it to actually define it up front. So I have 3 properties we can talk about today. One of them is a longevity in staffing, an inability to change the rank and file staffing of the agencies. And, Governor Hunt, in Governor Hunt 2, got embroiled in creating a whole large swath of rank and file as exempt, 1,500 out of 50,000. and went to trial on that. And in trial, he made the point that it was absolutely critical for him to have that many exempt positions so that he could then assure the loyalty of the rank and file. In other words, if you don't have that control, you're going to create this phenomenon of the administrative state. And so I think Mr. Governor Hunt got it entirely right on that. The second characteristic is that this entity demands deference. And it's managed to chisel some deference out in various ways, and both in developing the findings of fact and also to some level the interpretation of the law. So this entity demands some level of deference, and it's been granted some level of deference. And the last thing I'm going to touch on is it demands rulemaking and secrecy. It doesn't want transparency in the rulemaking process. And it's characterized a lot of times by rules actually masquerading as policy. And so there are a number of items we can go through, but I just wanted to, those are the three characteristics of this thing called the administrative state.
So let me follow up on a theme I've heard from all three of you. So when we're talking about administrative agencies, of course, one of the things they're doing is administering the laws. And I think this is where oftentimes ordinary people interact with government agencies. It's part of, I think, why a politician like Gene McCarthy finds it an easy group of people to pick on, the government bureaucrats, because ordinary people think of, like the IRS and paying their taxes, or they're standing in line at the DMV. Now they're thinking about, what is this government agency? But one thing you've all mentioned is this idea that there's also sort of a rulemaking function that's going on with administrative agencies. And one thing I want to read, so as many of you all know, John Locke was hugely influential in the framing of North Carolina's Constitution, both our original Constitution in 1776 and also the 1868 Constitution. There were a lot of things in our Constitution that are taken essentially word from word from something in one of the two treatises on government. And so one of the things that Locke said in the second treatise that I thought was interesting is, the legislative cannot transfer the power of making laws to any other hands. For it being but a delegated power of the people, they who have it cannot pass it over to others. And I think a lot of people not understanding administrative law would look at executive branch agencies making rules and say, wait, how does that fit with what Locke had described about the legislative power? So I want to ask each of you, and Judge Vandervoort, I'll start with you this time. How did we get here to this place where we have what we think of as executive agencies doing what seems to be legislating?
Well, the essence of the line, that the non-delegation line, is the complexity of what government is seeking to regulate. And there's been a lot written about how prescriptive statutes need to be to avoid the unfettered development of legislation within the agencies who are then charged. I mean, I'm very familiar with the environmental side. You could simply say, hey, clean up stuff, and that would be your statutory mandate. And from then on, you can get to the point of dictating, the concentration of 1,4-dioxin that should be in, certain waste streams. There's a chasm there. And one thing that agencies thrive on is to delve into the hyper-technical, to try to construct a wall between the legislative branch and the judiciary, to try to insulate their oversight, to insulate themselves from oversight. Just before I leave on this issue on rulemaking, North Carolina does not provide for judicial review of permanent rules. There is no mechanism by which individuals who are aggrieved can begin a judicial inquiry. That you can go to General Assembly, but for permanent rules, you're out of luck. The federal government does provide various routes. So this is just more insulation. And once you have given this phenomenon insulation from oversight, deferential treatment, staffing that transcends political changes and this ability to rule make with impunity, you're going to get the kind of results that we've got.
Sure, and I think Secretary Judge Vaart touched on the 1,4-dioxane rule, which it was not a concept at the time Locke wrote this, right? Now, there were certainly also a myriad of decisions that the Lord Proprietors and Parliament are making, but just the sheer number of people that we have in North Carolina and the sheer amount of decisions and information, I think it would be a challenge for a part-time legislature to continually revise or make a 1,4-dioxane standard. And so there has to be some confidence given in some authority if there's a general agreement that for the common good there should be a regulation of a 1,4-dioxane standard or a arsenic standard or whatever, flammability of children's pajamas standard, right? But if you take that there should be some baseline, then who's in the best position to make those decisions? Certainly there's some, in theory, expert deference that Judge Vaart cited to or mentioned that are cited with the people who perform this job. They're hired with qualifications to make those decisions. Admittedly, it's far afield from the world that John Locke wrote about, but the authority, I don't think, has changed. Maybe the gloss on that is that the legislature's sovereign authority to preserve its lawmaking ability also includes the ability to delegate those details, if not the authority, out to a third party.
John Locke is rolling in his grave. And I'll tell you this, my perspective from a constitutional view is that what we have now with the delegation of lawmaking authority to agencies, it would be very difficult for one who is intellectually honest to reconcile that with the text of the state constitution. And I say this for a couple of reasons. One, Article 1, Section 6, which is our express separation of powers clause, unlike the federal constitution, our separation of powers clause, or our separation of powers is tied to a specific clause in the Constitution. But if we look through, and I would encourage all of you to pick up a pocket copy of the Constitution if you haven't already, if we look at the article on the judiciary, that includes a specific provision allowing the General Assembly to vest judicial power in administrative agencies. So the people who wrote our Constitution and the people who ratified it know how to authorize the movement or the assignment of one branch's power to another power or to another branch. We know how to do that, and we know that we know how to do that because we've already done it. When we look at Article 2, which is the legislative branch architecture, and if we look at Article 3, which is the executive branch architecture, we see no such language. What we do see is that the Constitution spells out that the legislative power of the state shall be vested in the General Assembly that consists of the Senate and the House, right? So I have a very hard time finding honest support in the Constitution for the delegation of lawmaking to executive branch agencies. Now, what our court has done, and the sort of seminal case on this is from 1965, it's a Turnpike case, in that the court said, look, the supreme lawmaking authority can't be delegated, but the General Assembly can delegate these other things. The problem is they superimposed, no offense to the court, they superimposed the word supreme to qualify the legislative power, right? So that they could justify making that delegation. Now, the significance of the Turnpike Authority case being in 1965 is, of course, our current Constitution is in 1971. The study commission was underway in 1968. They were, they were fully engaged in revising, updating, and editing the Constitution. So we should all be, everyone in this room should be asking, why didn't we include in the Constitution a specific authorization that certain amounts of the lawmaking authority could be delegated to an executive branch? Now, of course, there are, as my co-panelist has pointed out, and a number of other folks, there are practical reasons to do that. Expert opinion, all of those things, but we should remain tethered to the Constitution, because this is what the people have mandated directly. So that's my thought is I think John Locke is having a really hard time looking down, or possibly up, but probably down.
Well, this is a good segue. Yes,
He's maybe
I
more
too think.
existential now.
Yeah, right.
The administrative state's ready to take on.
Right.
I get really excited about the administrative state, let me tell you.
Well, can I just ask as a follow-up to that?
Sure.
'Cause I think it's a compelling point on where alignment of separation of powers are, and it's an express duty here. There's language for judicial review for administrative agencies in the state constitution. There's language creating principal administrative departments that legislature can be given authority to, setting aside the sort of first principles of it. I mean, do you think those are sort of valid expressions of state sovereignty that the branches can draw some authority from?
I think the action of the branches needs to have a specific tether in the Constitution, in the actual text of the Constitution. Pragmatism be damned.
Sure. So like 3:11 and 4:3, right? Judicial powers of administrative agencies. Certainly, I think contemplates there being some sort of administrative authority that is granted to them.
Right, but that's my point, is that the Constitution specifically provides the General Assembly with the authority to vest in administrative agencies a judicial power. Even that is constrained by language limiting it to such as is reasonably necessary. Mm-hmm. But we don't see that same language. I mean, there are some portions, there's one portion concerning administrative reorganization that one might make a tether to, but that's not what we're seeing. What we're seeing is this tendency of courts to say, well, the legislature can't abdicate the supreme lawmaking authority, but if the people wanted to include the word supreme, to allow the General Assembly to delegate sort of lesser lawmaking authority, then the way to do that is by amending the Constitution, which we certainly know how to do because we do it not infrequently.
So I want to keep kind of following this point, but I want to ask it this way. So there's been a number of cases over the years that have talked about separation of powers from our state Supreme Court, because of course we have an express statement of separation of powers in our state constitution. And so one thing that this discussion, I think, raises is a question about, so I think if we can accept that we do have some non-delegation principle in North Carolina's jurisprudence that's similar to what has evolved, sort of this intelligible principle test that exists in the federal doctrine about, what can be delegated in terms of the sort of rulemaking or legislating from Congress to the administrative agencies. So here in North Carolina, when the General Assembly authorizes this rulemaking by an agency, my question is, in your view, are they performing a legislative function then that's sort of delegated, or are they the executive branch doing what's now an executive function? It seems to me that there's no clear answer in our doctrine. So what do you all think?
Well, I mean, from a practical standpoint, we can debate, how much to delegate. What is critical is that you have some checks and balances, so that if you grant an agency the ability for rulemaking, and in fact for various, for broad rulemaking, those rules ought to then be scrutinized, or you ought to be able to scrutinize those rules in the judiciary. And that way there can be a checks and balance on what the agency interpreted the statute to authorize them to do. But right now, we do have another check, which is that the legislative branch can come back in and say, wait a minute, that rule, that isn't what we wanted. But we don't have that third check. But, this isn't to say that agencies shouldn't be given some authority. Mr. McKinney is entirely right. You can't expect one branch of government to do all of the things that government is trying to do. But that doesn't mean that it can't be checked and balanced, because, humans are humans, and they're going to go off for whatever motivation and perhaps go too far. So that's what I would seek more transparency in the rulemaking process, and the ability to actually adjudicate those rules in the judiciary.
Yeah, and I think your question sort of gets to that sort of sphinx-like nature of what the administrative state can be like, or how parties in front of it or litigants perceive it. It's sort of like the old duck-rabbit proposition by Wittgenstein, right? What do you see here? Do you see a duck? Do you see a rabbit? Do you see a judicial process, or do you see a executive process, or even a legislative process, which I think we'd all agree would be an unconstitutional exercise then, if that's what it veered to. I think, to your point on separation of powers, and to what Judge Vaart said, there is a line somewhere there. There is a line on what the executive is able to exercise, consistent with the authority that the legislature has delegated, right? And if that principle or regulation or rule reaches a certain point, what is the administrative state's obligation in providing an evaluation of it, some sort of check? I mean, I think, you can look through the jurisprudence of the state where, I think prior to 2011 in the Regulatory Reform Act, right, an ALJ would make a recommendation, it would then go back to the agency, and then would be a final rule, and then could be litigated, and then you would take it up on appeal, and then hopefully you would only have to see it once, Justice Dietz, rather than on the second time around when it would come back. And before I don't know how many iterations the state trooper hat case, which was a regulation, and candidly a really fascinating inquiry into what truth-telling means, but how many iterations and how efficient that is for the administration of justice. I think, to answer your question, I think it has to be a judicial process at the end. I think as we were discussing Article 4, Section 3 on judicial powers of administrative agencies, certainly the safest ground it would strike me to be on.
I think this is one of the problems with having an administrative state, is that it's really come to exist almost as a nebulous kind of almost but not quite fourth branch of government, because it is very unclear where it falls. We know when agencies are promulgating these rules and the rules have the force and effect of law, that feels a lot like the legislative branch, but it's an executive agency. When they adjudicate, it feels like and looks like and is analogous to the judicial branch. So it's a very murky area, and that's part of what makes it so difficult for regulated industries and individuals and counsel to fit the pieces together. But it's certainly an area that I think we need to clear up.
I do want to kind of move us to talk a little bit about deference, because this is going to be a hot topic, I think, all around the country over the next year or so. Before I do that, I wanted to get you all to talk about, you may have heard in the introduction, Jeanette, you're the chair of this thing called the Rules Review Commission, which I feel like is one of the most, or least understood and maybe most underrated government boards that exist. So do you all want to talk a little bit about how that works? This is something you may not find in every other state. So what does the Rules Review Commission do, and what's going on there?
Okay, the very quick thing. Almost every rule or regulation promulgated by an agency in North Carolina has to go through the rulemaking process within the agency and then has to go to the Rules Review Commission. The Rules Review Commission reviews not at all. In fact, we are statutorily prohibited from reviewing for the policy or efficacy behind a rule. So what RRC does is review for compliance with the APA and the rulemaking process. We look for a lack of ambiguity. We look for statutory authority. That's really the point of the RRC, is that sort of final safeguard. And the RRC can either object to a rule, and then it's kind of left up to the agency, various options that they have thereafter, or we can approve a rule and then it becomes part of the code. And we are kind of unusual in that respect, and the history of RRC is pretty significant. North Carolina has had the Administrative Procedures Act since 1976. It was enacted in a special session in 1974, so even back in the 70s, the legislature was enacting pretty sweeping law in special sessions, despite what you might hear on mainstream media now. So it came into effect in 76. As soon as 77, the legislature was like, all right, this stuff is kind of out of control. They were concerned about the proliferation of rules and regulations. And so the APA was revised in 1985. And one of the things it did was create a Rules Review Commission rather than a committee of the legislature to review for those limited statutory criteria. But it is a very limited review. Again, no policy considerations at all. And we are an unusual body in that respect. And I think it's an area where it would be useful to have a lot more engagement from the legal community, specifically on things like statutory authority.
And the effect of the review is to void the rule?
Not to void it, no.
Or so then what does the review accomplish?
We can object to a rule, or we can approve it. We do not void it.
So, and then the effect of the objection?
That's really up to the agency.
Right. And here, I think it's really, it's the authority that vests in the commission is really interesting, right? In terms of understanding what the parameters are on which the review can take place, how an agency would then act upon that objection, presumably is to I think feel compelled to rewrite the rule or address the objection on the procedural or ambiguity issues, right?
They have different options. In fact, some of them take it to court, as is their statutory right.
Which again, while the agency can seek judicial review of an RRC disapproval, anybody who's affected by the rule cannot seek judicial review of the approval of a rule.
And so, just one more question then. This commission that you chair, the Rules Review Commission, where does the commission come from? Who chooses the members of that commission?
It's 10 members, and half are appointed by the House, and the other half are appointed by the Senate for 2-year terms.
So it's sort of interesting. We're now almost having whiplash. So we're talking about the legislature delegating authority to the executive branch, and then saying, when you use our authority that we're delegating to you, we'd like to have a commission that's looking over some of what you're doing. I think there's some controversy over that process, but I'm just curious, having just talked about kind of this, Lockean idea that really you're giving the power, exists in the legislature to begin with. Was there sort of something to the idea that if it is a delegated legislative power, it's sort of always a legislative power in terms of what the General Assembly can approve it or not, and who they want to maybe put in a position to do that. Do you all have any thoughts on that?
Well, I think it's important to understand that there is a lot of friction on the Rules Review Commission, but by way of a side history note, before the creation of the Rules Review Commission, there was a committee of the legislature that was performing essentially the same function. And there were constitutional concerns about that, which is how we ended up with this kind of compromise position of creating an RRC of non-legislators. But we need to also, another side note for those who don't know, if a permanent rule is approved and the RRC receives 10 letters of objection, it goes for legislative review, which is one more way that the legislature has attempted to maintain control over the lawmaking process. But as to a point that Judge Vaart has aptly and eloquently put a few times now, we need to also make sure that we have the safety of judicial review, and not just for those with the full power of the executive branch of government and the resources that come with that. Because, again, as Judge Vaart pointed out, agencies can take it to court. That doesn't mean that others can.
But I would agree that it is a check on executive power or executive authority by virtue of its composition and the effect of what a voided rule would do. Reminded of the Cosby Show. Trudy Cosby did the fan dance and said you can't put it out and then take it back, right? So it's sort of Trudy on delegation of authority. I think it's a question of exactly what you've put as to whether that commission, as it's constituted in its ability to review an executive action, where that falls on separation of powers issues. As far as I know, I think it's not been. It's an open question, and I think in full disclosure, a very interesting one, right? I mean, just as you think about the design and structure of a system, and obviously there was an appetite and a desire, as you note, after the Administrative Procedure Act came out, to kind of revisit what genie had come out of the bottle, right? But I think as it goes back to that sort of separation of powers structure, and whether it's even just justiciable as a separation of powers matter, I think is very much an open and interesting question.
Yeah, I think it's an incomplete check. As has been said, the RRC has a very limited toolbox in terms of what they can look at, and the 10-letter safety valve, if you will, was added when it was realized that, the RRC is only, it's only a very sort of, in some ways, procedural check. But just to be practical about this, the 10-letter mechanism almost never does anything. And the reason being is while the RRC is a pretty tight group that can actually debate issues, and they're all very well qualified, when it goes to the General Assembly, if there's something controversial that goes to the General Assembly, it's very difficult to get a majority to go up against a rule that purports to make life better. Whether it does or doesn't, that remains to be seen. But from an empirical standpoint, I've hardly ever seen, in my long career, those 10 letters doing anything other than simply delaying for a time being the effective date of the rule, and ultimately those rules go into effect anyway.
All right, I want to move us on to this interesting question, which I'm going to call deference. But I want to start it out by just saying it. Everyone's sort of heard, the whole channel your inner Chief Justice Marshall, and it's the court. What are the courts doing? We say what the law is. And you can find lots of examples if you go watch the oral arguments in our state appellate courts of kind of something that goes sort of like this. a judge will say, counsel, what's the standard of review in this case? And the lawyer who's at the podium will say, well, we argue that it's abuse of discretion. And they haven't disputed that in their brief, so they've waived any argument that it's not abuse of discretion. And then the judge will say, well, actually, counsel, you all are the lawyers for the parties, and none of you can stipulate to what the law is. We'll say what the law is. If that weren't the case, you could have litigants that come to court and say, oh, we agree the law is this, and force the court to accept that. So the general idea is the only people in sort of our system of government that say what the law is are judges, are the courts. But then you have this deference idea in the regulatory context that's a little bit different. I want you all to talk about, and there's all these different words that have come out of federal doctrine. So you hear Chevron deference. This is the idea that dealing with interpreting statutes. Then you have our deference with regulations. There's the Skidmore deference when you're in litigation. I don't, to be honest with three of you, even really understand what Skidmore deference is. So I'm going to turn it over to the three of you. What is going on with this idea that sometimes courts will defer to somebody else about how to interpret the law?
Well, maybe I can help. So in North Carolina, we have through the administrative process going over to OAH, there are some guideposts. Justice Dietz has already brought up a couple that are superimposed. So the APA, North Carolina APA, separates, as we all should, the decisions into findings of fact and conclusions of law. And these are oftentimes the level of deference and the kind of deference that either judge-made law or the APA confers to the agency. Almost always is confused at some point along the appellate process. And what I mean is that the deference afforded to findings of fact are confused with conclusions of law and vice versa. So I'm just going to bear with me. I'm just going to touch on a few that and a great partial explanation of this is in Justice Earle's dissent in Pinnacle that just came out. So the findings of fact, you would think that needs to be the trier of fact sort of advantage because they're seeing witnesses, et cetera. But during that period, the agencies historically have found themselves up against expert witnesses. And so there was a law that mandate that ALJs give due regard to the agency's expertise, the demonstrated agency's expertise, in developing the evidence. So in other words, the idea being is that you wouldn't have to qualify every agency staffer as an expert. You would listen to them on inferences and on matters beyond what an ordinary fact witness could offer. And that makes sense from a lot of standpoint. But the key here is that they have to demonstrate that expertise before you give them due regard. And we've got agencies that have a high rate of turnover. You've got instances where you might have expertise in one area, but perhaps there's a hole in another area because of whatever it is, lack of funding, just the fact that somebody retired, so when that expertise is not there, then the due regard should not be conferred, and that's exactly what Justice Earle said in her dissent in Pinnacle. She went a little bit farther than I think you might see an appellate court go in terms of delving into the actual facts, but that's a good illustration of that first deference. The second is on conclusions of law, and in conclusions of law, the OAH judges, ALJs, certainly are mandated by judge-made law to give some level of deference, whether it's an hour in North Carolina in Morrill. It has the most recent statement of our, which talks about giving how you're supposed to give some deference to an agency's interpretation of its own rule, which of course is fraught with problems, but it is what it is. And then, of course, there is Skidmore deference when ALJs are to interpret or listen to the interpretation of statute by the agency authorized to implement it. Now, what gets confusing, if that's not confusing enough already, is when it goes up to review under Article 4 of the 150B on the Administrative Procedures Act, the reviewing court is mandated to give de novo review on findings of conclusions of law on the final decision, whether it's from an ALJ or an agency. So I've also often scratched my head as to, does de novo review, when it goes to an appeals court, does de novo review mean that there is some deference that they then also infuse in that, or is it really just a de novo review? I think there's some confusion there, but suffice it to say that in North Carolina, we still have a little bit of our, although it's usually hitched to some U.S. federal decision, which as they start to deteriorate now in terms of trying to emasculate our, maybe that'll instruct North Carolina. And on the interpretation of statute, Justice Newby in one of his decisions made it very clear we are in Skidmore, and that is that not this idea of do you have a predicate of what ambiguity like you do in Chevron. It made very clear that there are some things to look at, the longevity of the position, some other items, but it is still labeled as Skidmore rather than Chevron. So that's just an attempt to confuse everyone.
You mentioned the Pinnacle, and I think Sound River is another recent opinion by the court. It's Justice Behringer that. Across both the majority opinion, the concurrence, and the dissent, there's an agreement that certainly the de novo review standard is what North Carolina applies. I think that aligns the state of North Carolina with Skidmore. I think you can reasonably articulate some reasons why a de novo standard review at a statewide level generates an acceptable amount of efficiency contrasted with what may be a necessity at a federal level for a 50-state survey of what Chevron deference could mean and how that might give more latitude to have local solutions or local statewide address of issues through Skidmore. I do think it's as we talk about vacancies within state government and turnover, that you have to acknowledge that what might be expertise from someone who makes a permitting decision on their second day on the job may look different than someone that makes a permitting decision after 25 years of making those kinds of reviews. And so I think your point on why that deference is applied within state agencies is I think a dynamic one.
Thank you. I think it's important to consider, one, to remember that we don't specific, as Judge Vanderbilt pointed out, our courts have been pretty consistent that courts are not bound by agencies' interpretations, but there is this tendency for things to sort of, for a little bit of an hour deference to sneak in and kind of in the trunk of a Skidmore deference. But I'd like us to think really fundamentally about whether to give any deference to agencies with respect to agencies' own rules or interpretive statements. If we think about it, compare it with, say, contract law. If there's an ambiguous provision in a contract, as we all know from first-year contracts, the sort of standard starting point is we construe the contract against the drafter. And we have similar veins in, say, the rule of lenity in criminal law. So why on earth would we give deference to an agency with respect to something it has had 100% control of writing, whether that's in the form of a rule or an interpretive statement? It seems fundamentally unfair. Also, it seems likely to encourage poor draftsmanship that's poor either because it's sloppy or because it is intentionally ambiguous so that government and bureaucrats and boots on the ground have an opportunity to perhaps manipulate it. So those are some policy concerns about giving deference at all. Now, I don't have those same policy concerns with respect to giving perhaps some non-binding deference to an agency with respect to its interpretation of a statute over which it had no control in the drafting. But I think there are serious and fundamental flaws with giving any measure of deference to an agency with respect to something it has drafted, whether that be in a formal rule, which has gone through notice and comment, or informal guidance and interpretive statements. Thank you.
So just one more follow-up about this, because this is something I think all three of you have touched on a little bit. So I think most people would say it's not clear that our state Supreme Court has ever suggested that Chevron deference, which is applying the agency deference to interpreting acts of the General Assembly, is something that we have embraced here in North Carolina. But just a practice tip for you all, if you ever need to find anything that you think is kind of sort of a wacky statement of law, just spend some time reading North Carolina Court of Appeals opinions, because what I tell people is look long enough and you'll find it. And sure enough, if you put Chevron into a legal search, you will find a ton of North Carolina Court of Appeals cases where they have cited Chevron and applied Chevron. In particular, I think in the context of what are called certificate of need applications. So this is a very heavily regulated area of healthcare about things like if you need a new MRI machine, you'll have to get permission from a regulatory agency in order to do that as a healthcare provider. And there's lots of cases in that context applying Chevron. And I guess I want to ask you all, because this is something that seems to be a pattern in North Carolina often, is that the appellate courts kind of reflexively, when there's no clear reason to do so, reach to federal doctrine and embrace some part of federal law without asking, does it make sense to have this as part of our North Carolina jurisprudence? So I'm just was wondering if you all had any thoughts about that, and whose fault that is. Do judges need to kind of be more protective of our own state law here, or what's going on?
We've seen that in some areas. Consider, for example, standing back in the Goldston Highway Trust Fund case. There's this brief moment where the Court of Appeals suddenly started citing all these federal standards for standing that fortunately the Supreme Court got in and was like, whoa, hold your horses, we're not the federal system. So we see that creep of federal jurisprudence, and I think there are a couple of things at play for that. One, I think it comes from the fact that we've got a lot of folks who are on blogs and in other legal spaces in the community where they're getting on really fantastic blogs, but those blogs tend to be focused not in North Carolina, they're focused on federal law. There's a lot of attention given, obviously, to SCOTUS cases. So it's there, right? It ends up in the recesses of your brain. So if you're trying to work out a complicated or novel issue, or an issue that you as a judge just don't have experience with, what makes sense to you is what you've been reading about for all these years. But also I think we have a fundamental flaw with our law schools, where there is an insufficient emphasis on the distinction between federal law and state law, and the uniqueness of our sovereignty, the architecture of our government as established in our Constitution. So I would like to see a greater emphasis on that. So I think we need to start with the baby lawyers, and then we also need, as members of the bar who are concerned about these issues, take the time to educate ourselves and our fellow attorneys about just how real and significant the distinctions are. But I think what happens is it's sort of the path of least resistance very often for judges and litigators.
Yeah, I think that's exactly right. In fact, I'll go beyond that, and not to be cynical, I'm just old, which is, the Chevron in its own, in the genesis of Chevron is so attractive. I mean, you're talking about a judge having to deal with, here in North Carolina, CON regs, which are crazy. At the federal level, the Chevron itself was an environmental case. if you get into tax law, it's incredibly esoteric. And so what better solve is it for a judge to be able to say, well, look, the agency's going this way. This is what they do for a living. They couldn't possibly be nefarious in any way, shape, or form. And yeah, I see some ambiguity in the statute. And boy, what a great thing to get a case off your docket than to say, oh, my hands are tied here. First of all, this is impenetrable gobbledygook that is at issue. And the agency, thankfully, has got something, where they are. And, by simply pushing that Chevron button, this thing gets ejected, and I'm on to something that I do understand, like, rape, murder, theft or something. And in North Carolina, I think the business court is one step toward trying to move in a direction where we, in every other profession, you've got specialty. You're not going to go see your GP to get a heart transplant. The point is that the business court is a step toward the direction of saying, bring on your hairy business transactional questions. We can handle it. And I think at some point in the future, there may be, we ought to think about trying to specialize a little bit more so that we don't force a judge to have to listen to this very wide span of very, very technical issues at times. And so I just think that's the genesis of this whole issue.
I'd offer Justice Dietz, you've probably been involved in more of those Court of Appeals opinion phrase than I will ever be. So happy to hear your thoughts on it. I would note, and I think Judge Vaart touched on this, but there are statutes under North Carolina law that are explicitly tied to and reference federal issues, federal law. My friend Chris Smith here can think of a couple, I think, offhand that would come to mind on that. And so, there is probably maybe, academically, that's an interesting question then. If you are, as a state court judge, evaluating a state law that references federal law, and that federal law is tied back to an administrative decision or federal rule, how do you, what lens do you put on that to evaluate it? And I do think that raises some delegation issues, right? In terms of what your authority is as a state official, what federal authority there is, and what sort of limitations there are on that, and how you as a citizen or a voter could promote accountability for sort of untying that, rat's nest of references, right? And so certainly, I think maybe beginning at the drafting stage, if laws are express about state authority to the extent it allows for, a functional process, maybe that helps unconfuse some of the references that you've made a point of.
All right. I want to save a little bit of time for questions, but so I want to move to a final topic. When I was first asked if I would moderate this panel, it was right around the time that it hit the news that the FTC had lost its antitrust lawsuit against Microsoft. Microsoft is trying to acquire Activision Blizzard, which is a very large video game company. And I thought, I wonder if there's been a lot of criticism of the FTC and its chair, Lena Khan, and I thought, I wonder if this will be relevant by the time we get to this panel. And I think it is relevant because if you've been watching the news, the FTC has moved on. So they started with Meta, they moved to Microsoft, now they've just filed a major antitrust suit against Amazon that's been in the news. So I thought we should talk a little bit about this criticism that seems to me a little bit new, which is this idea of like the quote activist regulator. And so I went back and this is the NPR article from early in 2021 when President Biden had nominated Lena Khan, and she's going through confirmation, chair of the FTC. And the article says, Lena Khan, prominent big tech critic, will lead the FTC. And so I think that was part of the controversy initially. It was that Lena Khan is best known for having written a very famous paper suggesting the only way to stop the big tech companies is sort of to break them up. And now she's the head of the government agency that decides whether or not to pursue that kind of action. But I'm not sure. I think there's always been a sense that appointees to these regulatory agencies, the political appointees, will pursue some sort of political mission that's tied to whoever the official was that appointed them. But what I found most interesting about this was, so the press reported that Khan at a conference was asked about these lawsuits, which, I should have emphasized, the FTC lost the lawsuit against Meta, lost the lawsuit against Microsoft. And so Khan said, generally, it's okay not to win cases as a regulator, because by losing, sometimes we draw attention to gaps in the law and Congress takes note. And what I thought was interesting about that is, when I first heard it, that actually made a lot of sense to me. But then it also occurred to me that you could make another sort of a counter argument to that, which is, well, but that's also allowing you to regulate in areas Congress doesn't want you to, because the unlimited resources of a agency like the FTC means if you bring a lawsuit, you may scare off a lot of other people from doing a similar thing. So I was hoping you all could talk a little bit about this idea of regulators as kind of pushing the envelope here, where you think the line is, and what regulators can and can't do with this power they've been given.
We should see if Jennifer Mascott's still available to dial in. I think she probably would have the best perspective on that as an FTC matter. I mean, I think you're absolutely correct that there are virtually limitless resources from the state in pursuing cases like this, and maybe near limitless resources from Meta and Microsoft. It was sort of the battle of the dinosaurs, or Godzilla and Mothra to a certain extent. And so I think that's a fair, I think it's a fair observation on your part of what effect that has on market activity. I'd say whether it's at the FTC or at the state level at a DEQ, regulators have a job to do, and they're given certain discretion and authority in making the evaluation. I don't know if losing a case necessarily draws as much attention for congressional action as one might hope, or it just reemphasizes the need, the feeling that the law is sufficient on it. I think it's a fair point that it's an aggressive point to make from a regulator in terms of justifying what your authority is. It seems to me that regulation typically is best served in exercising what authority's been delegated to you, rather than maybe pushing a boundary to test a new principle in the law.
I think it's part and parcel of the idea that government wins by slowly losing. Right? When you're talking about the FTC up against these enormous corporations with virtually limitless resources like Meta, when they lose, they can just pick on the next target. So yeah, they lose, but eventually they'll get to one where things line up for them. When government is up against smaller businesses, mom and pop kind of shops, or individuals, they win by, if they can't win on the merits, they win by dragging out the litigation, so it's cost prohibitive, and mom and pop just sort of throw their hands up and say, well, I guess we aren't going to do what we wanted to do. And I think there is some usefulness in either government or nonprofit public interest kind of organizations bringing litigation. Even if you lose in court, you've raised public awareness, you've raised awareness within the legislature and other agencies about issues that should be clarified by the rule of actual law. So I think there are a number of those dynamics at play that are worth considering. But we should remember that government very, very often wins by slowly losing.
I would only just add that the only thing in between overreach by an agency is the judiciary. So this simply illustrates the importance of the selection process for those people who are put in the position of being judges.
All right, well, we told the organizers we'd save time for questions, and we've got 3 minutes. So if someone has a question for the panelists, we can probably do one question. Sir.
Yeah, thank you. From my area of expertise in higher education, I've been particularly concerned with the problem of the administrative state, federal and state, essentially that won't repeal duplicate or contradictory legislation / rules / regulations. And so essentially what happens with higher education, colleges, universities all across the country, private and public, is there's more administrators at the schools than there is faculty. And they're the ones that get raises and high rates, et cetera. And yet their faculty, chemistry, math, et cetera, this important STEM background of our technological expertise here in the US. What can you all, as in your own areas of expertise, can you comment please on the fact that people are unwilling to deal with those duplications or contradictions that essentially feeds the administration excess in higher education? Thank you.
I don't know if I can offer much to add on that from my perspective on what the administrative state sort of culpability or responsibility is in an over bureaucratized or over expensive higher ed process. Certainly, what I would point out is that North Carolina courts do hear administrative rules in personnel cases involving higher ed faculty and staff members in North Carolina. And so I think the jurisprudence that they provide sort of gets the ball rolling on what obligations or actions a particular at least a public higher education enterprise can undertake here in the state.
Good.
The conflicts are not unique to higher ed, and they are not unique to the dual sovereignty. So we end up with conflicts not just as between the state and the feds, but we will end up sometimes with conflicts between agencies at each of those levels, where one agency says, oh no, this is my turf, and the other says, oh no, this is my turf. And then we, interestingly enough, have certain statutes where the rulemaking authority is granted simultaneously to different agencies. We see that often in environmental law. We see it with midwifery as totally random. And that's part of what is so problematic about the ever-expanding administrative state, is that the bigger and more powerful we make the administrative state, the more pronounced the problems are with those conflicts as between state and fed, but also in intra-level agencies. And that, again, it's not unique to higher ed. We see it across the board, across the policy spectrum, and it's going to get worse before it gets better.
All right, well, I think we're out of time, so please give a round of applause for our panelists. Thank you all so much.